A pardon is an act of mercy granted by the president to a convicted prisoner or person, not an unconvicted one. Because the others were saying, but this is the time now to release Besigye because he has already released the others. The pardon goes to a person that has been convicted, not a remand, relieving them from all or part of the legal consequences of their offense. A pardon may be free or unconditional, or it can be conditional, subject to the lawful terms set by the president as prescribed by Article 121. The prerogative of mercy, as provided for under Article 121 of the 1995 Constitution of the Republic of Uganda, is a key constitutional mechanism that allows the president to exercise compassionate intervention in the administration of criminal justice. This power, however, is not exercised in isolation. It is guided by the advice from the Advisory Committee on the Prerogative of Mercy. And that's what is there, how it is constituted and who is there and what it does. Ensuring that decisions are grounded on fairness and due process and national values. Not personal values, but national values. Under the constitutional mandate, the president may extend clemency to convicted persons in several forms. These include granting a full conditional pardon, offering a temporary or indefinite respite from the execution of the sentence. These are matters of law. This English is not mine. Don't hang me. This is, I have to extract it as it is. Substituting a lesser punishment or remitting the whole or part of the punishment, penalty or feature. This flexibility allows the prerogative of mercy to address exceptional circumstances, promote rehabilitation and reintegration. In cases where a person is sentenced to death, Article 121 further provides a strong safeguard by requiring the submission of detailed written report from the trial judge or presiding officer, along with any other relevant information to the advisory committee. The article also clarifies that these provisions apply not only to civil courts, but also to courts of conviction, sentence passed by the military courts, tribunals, except the field court marshals. Collectively, these measures ensure thorough scrutiny, humanity, and constitutional criteria for qualification of pardon. How does a person fall into this category? In reference to Article 121, Section 1, 2, and 3, the Advisory Committee on the Prerogative of Mercy is composed of 7 persons of high integrity, namely the Attorney General as its chairperson and 6 other prominent citizens of Uganda appointed by His Excellency the President. The committee applies a comprehensive set of legal, humanitarian, and behavioral standards when assessing inmates for possible pardon. These criteria ensure fairness, accountability, and readiness for lawful reintegration into society. They are usually derived from the detailed reports submitted by Uganda prisons under the strict supervision of the Commissioner General of Prisons. Therefore, the following are cardinal areas to look at. 1, the nature and circumstances of the offense of which the person is convicted. 2, discipline and general conduct of the prisoner. 3, hard work and productivity of the prisoner. 4, remorsefulness and personal reform of the prisoner. 5, health condition of the prisoner. 6, gender, age, and vulnerability is also one of the considerations in assessing these 5. Then we look at public safety and security consideration. If you are a serial killer and you expect to get pardon, no, They look at how many people have been on your file for death. So that's why public safety and security considerations are very important. But all this, there must be a recommendation from Uganda prison authorities. And from that, we go to categories of prisoners who benefit from pardon. The category number one, we start with capital offenders. Capital offenders are those who have been charged and sentenced of offenses that would lead to death. And that's why number one is that all death row inmates, prisoners sentenced for hanging, who have completed the appeal process and are waiting for the president's decision, fall in the category to be submitted for pardon. By the way, the president's decision can be either. It can be either pardon or hang. Even when the president is signing for hanging, he uses the same article, 121. 2, all capital offenders with 6 months or less remaining on their sentence, they are eligible for submission for pardon. 3, the elderly capital offenders aged 64 years and above who have served at least 75% or 3/4 of their sentence are qualified to be submitted for pardon. Pregnant and suckling mothers who have served at least 75% of their sentence also qualify to be on this list. And the terminally ill or chronically sick capital offenders whose continued incarceration poses serious health risks and have served 75% of their sentence, which is 3/4, they also join this list. Now, that's why in most cases, this list, this first category alone, generates over 1,000 inmates. This one alone. Category B is pet offenders. Those who are snatching necklaces, sentenced minor offenses. Now, all convicts on minor offenses, of course those ones, their sentences don't exceed 2 years. On minor offenses, who have finished 50% of their sentence, qualify for this pardon. 2, the elderly who are aged 64, still pet offenders, and who generally, with them, they don't even need to go that far. As long as they can be identified in the review by the prisons, then the committee can assess further and recommend to the president. The pet offenders with serious medical condition, disability, or other compelling human circumstances that justify the release, they also fall in this category. And we have also the pregnant and suckling mothers who have finished 50% of their sentence. Those are the categories of people who qualify for pardon. And actually, we submit a return to the Prerogative of Mercy Committee once in a year or any other time when the committee wants. I had said there was, then there is a special, the last one is this special category. That inmates who, regardless of age, offense, or have demonstrated extraordinary rehabilitation and remorseful and readiness for social integration can be considered without looking at how much they have covered. And then the next step is, how is this pardon? What is the process? How does it start? How does it conclude? So the journey of pardon file is rigorous and follows due process. Step 1, the process begins at the station level. The officer in charge where the inmates meeting the criteria are identified. Their files are compiled and reports are prepared for each inmate. Each inmate, there must be a report. Step 2, these reports are forwarded to the Commissioner General of Prisons for verification, scrutiny, and review. Because the moment he puts a signature that he has forwarded, then he takes responsibility. Step 3, reviewed lists are sent to the Attorney General at least once every year. Sometimes the committee requests for reports on individual convicted prisoners for specific review. In certain cases, individual prisoners petition the president directly for pardon through their lawyers. These petitions are then referred by the president to the Prerogative of Mercy Committee. Then they also work backward, getting specific reports from us. Step 4, the committee reviews the cases and submits its recommendation to the president. And finally, once the president signs the instrument of pardon, the directive flows back through the Attorney General to the Commissioner General of Prisons, and finally to the specific prison units to effect the release or sentence adjustment, which must be implemented within 24 hours. The moment the instrument lands, in 24 hours, people must go, or the adjustment must be made accordingly. If it is death, that one is a bit longer. They give us 72 hours. We prepare those for hanging in 72 hours, and we are done. Now, I decided to compile the statistics because somebody was saying that this is being done because of the politicking going around. So I decided, why don't I bring the statistics for these 5 years? Now, by now, actually, in this term, from 2020 to 2025, a total of 1,798 prisoners have been pardoned. To be specific, on 22nd April 2020, 833 inmates were pardoned. On 25th May 2021, 579 inmates were pardoned. On 3rd of January 2023, 13 were pardoned. On 20th August 2023, 2 were pardoned. When you see like these numbers small, that means that the petition went through the president backward. When you see the bigger numbers, then that means these were emerging from the submitted reports. On 15th October 2024, 130 were pardoned. On 16th November 2024, 19 were pardoned. And lastly, on 4th October 2025, 143 were pardoned. That one makes them a total of 1,798. So it becomes absurd if you say that this recent pardon is targeting politics. The president has to exercise his constitutional powers like he has always done. In conclusion, prerogative of mercy or pardon is a constitutional obligation and the discretion of the fountain of honor. It's its intended general outcomes are to extend philanthropy and facilitate periodic decongestion of prisons, and it is purely political. To note, pardon exclusively benefits convicted prisoners.